This opening segment is less about missed payments and more about priorities. The court quickly identifies a pattern that appears in many child support disputes, a parent treating support as a bill that gets paid only after everything else is covered.
Can you all hear me?
Yeah.
Oh, I can hear now. Okay, sorry about that.
Kayla Brooks appears, apparently representing herself at this hearing. Susie Alok appears on behalf of the Office of the Butler County Court Trustee. Who else do you have in your office with you, Ms. Locke?
Your Honor, this is Aaron Moore, who I represent privately, who is also set on the 130 docket.
All right, fine. Why are we here on this docket today involving the Kayla Brooks case, Ms. Locke?
Your Honor, I filed a motion for an order to appear. Respondent was, which is mom, Miss Brooks, was ordered to pay child support. And her last payment as of my records from the Kansas Payment Center was November 21st of 2025. And so we're here asking for an update regarding her intentions to pay and new employment to have an income withholding order issued.
Ms. Brooks, it's been suggested to the court that you're not meeting your child support obligation.
Yeah.
Why is that?
I haven't been able to afford it.
Okay, are you working?
Yes.
Where do you work?
It's called Premier in Udall, Kansas.
What do they do?
Manufacture plastic airplane parts.
Okay. All right. And how much money do you make at that job?
$18 an hour.
But you're not paying your child support?
I haven't been able to afford it. I mean, my house payment is $900 a month, and plus keeping the lights on and all that kind of stuff. Like, and I had gotten into legal trouble, so I was paying that. And now I can actually pay it off. I just got my second check from this job. But I'm not sure how to even go about paying off a huge lump sum. I tried to do it last night, but I don't know how to do it.
Well, for sure, you need to be making your current child support obligations every month.
Mm-hmm.
Okay. Well, Ms. Locke, we now know where she works. What is the current child support amount in this case?
It's $298 a month.
Okay. Presuming that we're going to try to address the problem here with an income withholding order, how much are you requesting in arrearages, and do you have an arrearage figure to suggest to the court?
Your Honor, I calculate arrears at not less than $1,788.
Okay.
Which is her obligation from December through May, today being May 1st.
At this point, I'm going to set a relatively modest income withholding figure of $60 a month on top of the $298, which would cause an overall withholding of $358. We're going to get this set up where it comes out of your check, Ms. Brooks. And
Okay.
that way, you're not going to be making discretionary calls about what you pay and what you don't pay, rather that this will be paid off the top.
Yeah.
And then you won't get in further child support trouble. Maybe you can't afford a $900 a month house payment. You may have to downsize or whatever's necessary. But child support is an important obligation that has to be paid first. Everything else is secondary, except maybe taxes, according to the government. But other than that, you need to make sure this gets paid, and income withholding will help facilitate that. All right. I think that she's provided some valuable information which may help remedy her current non-payment and or arrearages situation. Is there any other relief that you're seeking in the Brooks matter at this time?
No, Your Honor.
Okay. You have any questions about what we've done here today, Ms. Brooks?
No.
Okay, very well. And I think that adequately addresses the Roby and Brooks matter at this time. We'll move on to another case on the docket. You can leave the meeting if you want to at this time, Ms. Brooks.
Okay.
Right, and it's my understanding, Ms. Locke, that Aaron Leanne Moore is right across from you in your office?
Yes, current last name is Jones, Your Honor.
Okay. The court will call the case of the matter of the paternity of WW, a minor child, by and through parent Aaron Leanne Jones and Scott Wesley Watkins, case number 2020 DM 304. The mother, Aaron Leanne Jones, appears in the office of Susan Locke, her attorney. There's no current appearance by Scott Watkins. Did you get notice to Mr. Watkins?
Yes, Your Honor.
And in what manner did you attempt to notify Mr. Watkins of today's hearing?
He was provided notice by mail in January of 2026. This case was originally set in October. Well, actually, we were heard in September. The court made findings and then continued to the case to see if Mr. Watkins was paying consistent with his income withholding order. He is. However, he has failed to provide us with updated income information as requested on multiple occasions.
Do you have some reason to believe that his income has increased?
Judge, we believe that he is making more with KDOT. He had indicated to my client and the minor child that he had a raise. However, again, we don't have any of that income information.
Perhaps could be remedied with a business record subpoena to the Kansas Department of Transportation, Ms. Locke. I'm not suggesting that that relieves him of any responsibilities that he has, but certainly the information should be accessible if he works for a state agency.
Yes, Your Honor.
All right. Was the original action that brought him before the court a contempt action or something else?
Yes, it was a contempt.
The second case reveals a different problem entirely. Here, the issue is not outright refusal to pay, but a failure to cooperate with the process. The father's absence creates a credibility problem before any financial question can even be addressed.
I see a journal entry from motion to appear. That may be the last substantive journal entry in the case. Fix an arrearage amount. Did he pay the $295 for the costs and fees associated with his failure to appear?
No, Your Honor.
I'm somewhat reticent to consider him in default. I don't really have a court order, unless you're aware of one that I don't see, that required him by court order to be here today. I do understand that you gave him notice, but
Judge, that same journal entry that you were reviewing does have the hearing information at the bottom. It doesn't necessarily say that he's ordered to appear, but we also filed the amended notice of hearing. He was supposed to appear in January, that got continued, and we filed an additional notice.
All right, are you seeking additional relief here?
Not for today, Your Honor. We anticipated that this would be a review hearing and he would be present to provide any updated information, but he is not present.
And you're privately retained counsel for Ms. Moore, correct? Or Ms. Jones?
Yes, yes, Your Honor.
Well, the court at this time will order that Mr. Watkins to be responsible for the legal fees and expenses which would be connected with a subpoena of business records. If that's what you elect to do, Ms. Locke, he should reimburse your office or your client for that time. This shouldn't have been necessary. I agree with you. If he received notice of this hearing, he didn't appear to provide the information, and you have to subpoena that, he should be responsible for any legal fees connected with that additional step of the subpoena of business records. So Are you seeking an additional review hearing on the calendar?
Judge, because he's paying consistent with the prior order, I wouldn't request an additional review. I will file a motion to garnish his wages for the $295 and any additional expenses associated with the subpoena.
All right. That will have to be reduced to judgment at some point. Perhaps there is a realistic determination that we can make today about what time will be involved in it. You've issued many of these, Ms. Locke. How much of your time is necessary in the preparation of the subpoena of business records and its service?
Judge, I would anticipate that'll be approximately $100.
Then please include in any journal entry which stems from today, Ms. Locke, an additional judgment. Of course, that in good faith means that you intend to issue that subpoena of business records.
Yes, Judge.
I think justice and equity requires that a judgment against Mr. Watkins for legal fees for Ms. Locke in the amount of $100 is appropriate, and the court will make that order. Okay. And if you'll prepare an appropriate journal entry stemming from today, which documents what we've handled here in court today.
Understood.
All right. Anything else, Ms. Locke, that we need to address at this time?
No, Your Honor.
Very well. Then if there's nothing further in that case, that should conclude this segment of the docket. And I think we can go ahead and just leave the meeting open for the 2 o'clock, Mandy, but Ms. Locke and her client are free to leave unless she's involved in the 2 o'clock case.
Judge, I don't think I have any additional cases on the docket today.
Very well. Then you can leave the meeting at this time.
Thank you.
We'll resume the docket at this time. I have a case, Secretary of Department of Children and Families versus Alan Milton Furman III, 2014 DM 165. I think Mr. Furman may have been on the meeting earlier. I think he is an incarcerated inmate, but he's not on the meeting now, apparently. Ms. Hawks, I think we can address this relatively quickly. There was a motion to modify child support in that case, 14 DM 165, apparently acknowledging that child support needs to be amended because he's now incarcerated and can't earn income. Is that the purpose of the modification?
That is correct, Your Honor.
And essentially, your proposed child support worksheet for Mr. Furman at this point is a zero child support order, apparently in as long as he's incarcerated. Is that correct?
Correct, Your Honor.
Very well. He's not compromised by not appearing today. I mean, we're taking his child support down to zero. So the court will go ahead and approve your child support worksheet and ask you to prepare an order which modifies child support accordingly to a zero child support order during the times that Mr. Furman is incarcerated.
Thank you, Your Honor. And I would ask for leave to issue an income withholding order for either $2 to $5 a month because he does have significant arrears.
Do you have any reason to believe he has income within the correctional facility?
Generally, inmates make sometimes around $9 a month. That's why I would ask for the 2 to 5.
Court will set the figure at $4 a month.
Thank you, Your Honor.
And you can include that in your order.
Thank you.
Any other business we need to conduct regarding the Furman case?
Nothing further from the state.
Very well. Then that matter will be in recess. We'll move on to another matter that was scheduled for the same time on the docket, in the matter of the marriage of Megan Pope and Kelly Pope.
This section demonstrates how child support law often separates obligation from ability. The incarcerated father is not portrayed as irresponsible or unwilling. Instead, the court confronts a practical reality. Support calculations must reflect actual earning capacity.
Case number 2025 DM5. Ms. Hawks appears on behalf of DCF and Child Support Enforcement, but I also note the appearance of Kelly Pope, Megan Pope, and Susan Locke. And you are counsel for Megan?
Yes, Your Honor.
All right. There was a motion to modify child support in this case. There was a response to the motion filed by Ms. Locke on behalf of her client, asking that some other matters be considered here. Have the parties reached agreements on any of these matters?
No, Judge.
Okay.
No.
Let's start with Ms. Hawks. What are you seeking regarding court orders today?
Your Honor, the state prepared a child support worksheet and it shows a guideline amount of $1,826 a month. The current order is $2,150. I believe that's an appropriate amount. As I know, one of the issues raised was the income tax consideration included on the child support worksheet. The parties divide the income tax, the children for income tax purposes. So mother claims Elijah and Adelaide, and father claims Noah and Rosalie. Noah is over 17 and he's no longer available for the child tax credit, and I believe that's where the difference comes in of the $46 on the child support worksheet. So I still believe that's appropriate. As to mother's claim about uninsured medical, DCF doesn't really get involved in that. Once there's a judgment, we will help collect, but otherwise that's mother's issue to plead. And then as far as father's income, mother's claim about father's income, I use the information that was prepared on the domestic relations affidavits. If the parties don't believe that's sufficient, then I think we would need to continue this for further information. So that's the state's position.
All right, Ms. Locke, your response to Ms. Hawks' positions in this matter?
Yes, Your Honor. Regarding the tax credit first, the parties are alternating the third child. So it is accurate that they were both claiming two, but now the order states that the third child gets alternated every year. So that was the basis for us requesting that that income tax credit be removed, as annually it would be adjusted. So we would stand behind that request that that be removed from the child support worksheet in favor of the divorce decree. I appreciate that DCF does not enforce the medical piece. However, there is a place on the income withholding order for medical expenses to be included. We have pled, and Mr. Pope did not respond to our position that he be 100% responsible for the medical debt that he was supposed to share in. That cost, which was provided to him on January 24th, to which he never shared the cost in, was $1,404. So we are asking the court to assess that in the income withholding order. Additionally, Your Honor, there is arrears that are owed on child support.
Let's back up a minute. What's the authority for the court assessing all of that to him?
In the decree, Judge, if a party fails to pay their share of a medical expense within 30 days, the court can assess up to 100% of the uninsured balance and attorney's fees to the party that's seeking reimbursement.
Doesn't that presuppose that the requesting party hasn't paid their share either?
My client paid 100% of the costs in order for the children to maintain their, they go to like a concierge doctor, and it was their annual payment. And so she had to remit 100% of the costs in order to maintain that provider.
Page of the decree that this provision is on, Ms. Locke?
Yes, Judge, it's on. Let me scroll. It starts, paragraph 9 starts on page 5, and this is addressed on page 6, paragraph D, subparagraph D.
Is it your client's position that he made no efforts to address this matter within the 30-day period?
Yes, Judge, and attached to our motion were the emails that were sent to him to which there was no response, which included the invoice.
All right. Thank you, Ms. Locke. Further argument that you wish to make?
Yes, Your Honor, there are arrears in this case, or we believe that there are arrears which are not accounted for by DCF. And so we're just asking that an arrearage calculation be completed by DCF and the appropriate amount be added to the new income withholding order.
Well, if you're saying that their arrearage order is incorrect, you've obviously done your own, correct? To know that? So
Judge, they did not.
The discussion surrounding medical expenses exposes an important courtroom dynamic. Documentation alone rarely ends a dispute. The real question becomes whether a party ignored a responsibility after receiving notice.
DCF did not do an arrearage calculation, but Mr. Pope has not been paying consistent with the prior court order.
Okay, I was just looking at the file here. As of January 2026, there was an order determining arrears. Is that what you're taking issue with?
Yes, and there should be additional arrears, but those, I don't see that they're in their motion that they asked for an additional portion to be paid towards the arrearage. And so we're just asking that some amount be assessed to be paid towards that arrearage.
And for them to go back and do a new child support arrearage computation?
Just update the calculation, yes, Your Honor.
Your Honor,
what is your position in that regard?
Your Honor, right now we're showing arrears of $4,471.23. If Ms. Locke wants a formal arrears calculation, I mean, I have no issue. We can go ahead and prepare that. And I was today going to ask that an additional amount be added to the income withholding order for those arrears. That's kind of standard practice. It just wasn't included in the motion.
What figure are you proposing in that regard?
With this amount, I mean, I would ask for at least 100 a month.
We would have no objection to that, Your Honor.
Okay. And as far as the arrearage calculation, you are willing to update that, Ms. Hawks?
Yes, I can prepare an arrears calculation. Does the court want that filed or just sent out to the parties?
Well, I would want the new arrearage number stated in the order which stems from today's proceedings.
Thank you, Your Honor.
I don't know that backup documentation necessarily has to be attached to it, but it can be just sent out to the parties. So before I address Mr. Pope, I want to make sure that I've reconciled any issues that exist between counsel at this point. Ms. Locke, are there matters that you wanted addressed that haven't been addressed yet? There's the tax credit issue. Obviously, the decree controls to the extent that it applies to a situation. So, Ms. Hawks, are you taking issue with the way that the decree reads and how it should be applied here?
No, Your Honor.
Okay.
And the only other thing I'd like to say is I just want to clarify as to the uninsured medical. DCF will 100% assist in enforcing any judgment. If I said that incorrectly, I just can't assist in any argument in obtaining a judgment. So.
All right. All right. I want to address Kelly Pope at this point.
Yes, Your Honor.
Oh. Apparently you were sent $1,404 of medical expense documentation back in January, and you didn't respond to it?
I have never received it. If they send it by email, I get hundreds of emails per day, and I've never received anything about that. And when Megan and I have spoken in person about the medical stuff, she has always said that she's not worried about it because she knows I can't even pay my own bills right now.
Okay. All right. You say you never received it. You never received it, or you may have received it and you just never noticed that you had it?
I mean, it may have gone to my spam folder. It may be, I mean, like I said, I get hundreds of junk mails per day. Every week I go through and delete thousands of emails and that are junk, and I have never seen it.
Or that would beg the question, then why was there no follow-up? I mean,
Because I never saw it.
okay, just a minute. This is really for Megan.
Okay.
She never followed up on this after sending an email?
Judge, I'm going to let my client speak to that, Megan, if you want to unmute.
Okay, yes. There was a response email from him. I'm looking at it right now. I don't know if that wasn't attached when I sent it to Susie. But he said, again, currently unable to even pay my bills. So unless something changes, I'll be unable to pay that.
Okay,
So let me go back and look.
He responded on January 24th.
okay. That's the information I was looking for.
Let me go back and look, because I do not remember ever even seeing that. I remember Megan asking me about it or something like that, but I do not remember ever seeing any documentation attached to anything. I got my email account.
I just want to make sure that this is clarified. The $1,404, that was Kelly's portion of the bill? Or that was the total bill?
That's the total bill, Your Honor.
How much was his share of the bill?
He is obligated, let me check in the decree unless it's different. He was obligated to 62.2% of that, which I will calculate real quick for the court. Which was $870.48.
Okay, and I do see that in my email. I just never saw the attachment.
Court will grant judgment in favor of Megan against Kelly in the amount of $870.48 for unreimbursed medical expenses, apparently pertaining to a child or children of the relationship. However, the court's not inclined to assess the entire amount in this case. I think there was also a request for $250 in legal fees. Ms. Locke?
The father initially claims he never received the documentation. Moments later, evidence surfaces showing that he actually responded to the communication. That shift weakens his position immediately. The judge is not openly accusing anyone of dishonesty, but the contradiction changes the courtroom atmosphere.
Yes, Your Honor.
This is something that should not have to be done through an attorney for enforcement purposes. Mr. Pope, if you take care of it, then these things don't happen. Court will assess an additional $250 in legal fees. That looks like a total judgment of $11,2048. Check my math, Susie.
Yes, Judge.
And I understand money's tight, Mr. Pope, but these are priority payments in the view of the law. Child support, spousal support, and medical expense reimbursement are all critical expenses. They just have to be paid.
I understand that, Your Honor, but I'm talking like I can't pay my bills. My basic living expenses I can't pay. Permission to address the arrears.
Yes, you may.
The case in January, they determined that all the arrears had been paid, and Megan actually had got on with the judge and stated that all those arrears had been paid. But then for some reason, DCF never canceled it out to zero. They left a $2,000 remainder approximately in there. And I have questioned that several times, and I even sent them a copy of the order saying that it was brought to zero, and they have never adjusted that. So the only thing that should be unpaid is I did have one where I was trying to make a payment of $2,330, and that was returned because I didn't have enough in my account. And so I made a $1,500 payment, and I do still owe the remainder of that month, which should be about $3,000 something dollars. And that was, I believe, 3 months ago. Other than that, every month has been paid in full.
I do find it interesting that back in December of 25, the income withholding order for support shows 0 for past due. So, Ms. Hawks, does he have an arrearage amount or not?
Well, Your Honor, I do want to point out we're enforcing on child support and spousal support, and the spousal support is $2,155 a month, and the child support's $2,150, and the income withholding order payments are, I mean, sometimes they're $35, sometimes they're $150, and then he's supplementing with cash payments. So they're not consistent payments. When I will send an email to our finance department after court today, I will include the order from September showing that the court found that he owed no arrears as of September 30th of 2025, when for them to calculate child support. I'm so sorry, for them to calculate arrears. But with that level of obligation, I mean, he owes over $4,000 a month in obligation between the two. It's easy to get behind.
Okay.
So
So there very well could have been a considerable arrearage generated since September 30 of 2025.
that is correct, but we will verify and send the arrears calculation out to the parties.
All right.
And that's what I was saying, that I had that 1 month where I didn't have enough to make the full payment, and I paid just $1,500 for that month out between and I combined the two into one payment. Every other month I mean, you can look at the payment history on the DCF website. It's every other month has been the full $4,355 a month.
Well, we want the arrearage figures coming out of today's proceedings to be correct. That's the bottom line.
Yes.
As computed through April 30 of 2026.
Correct. I did have one other.
She said that she's going to have that recomputed.
Yes.
Based on appropriate circumstances, and then that figure should be included in the journal entry, which stems from today.
Yes, Your Honor. There was one other thing that I noticed on her computation that was incorrect. She has my entire income listed just as domestic gross income. Basically, all that should have been on there was my VA disability, which is it's currently $4,386 a month or something like that, and the money I was getting from the oil checks, which is inconsistent. The remainder of it is as an Uber and Lyft driver, which is 1099 contractor and therefore self-employed, which means that all of my expenses, like my gas, which is $1,300 a month, should be coming out of that prior to the calculation.
Is this matter before the court for modification currently?
Yes, Your Honor.
Okay. These aren't new circumstances. This has never been factored in before?
No, that's what I put on the worksheet when I sent it out to them, was that it was self-employed 1099 contractor. I put my expenses on there, but then on the worksheet that they filled out, they put it all just under domestic gross income and still self-employed.
With no expenses deducted.
With no expenses deducted, correct.
Your Honor, which I will point out, that's how the original child support worksheet was prepared as well in this case.
With no deduction for expenses?
The original child support worksheet was based on our tax return that was still filed jointly from 2024's tax return. I didn't have a new job or anything yet at the time of the divorce. I was in training at one, but then it didn't work out. So I was getting $90 per day flat fee. And they said somehow I was making $100,000 a year. I'm like, no, there was no way I was making that $90 a day flat. So I have no idea how they calculated that in the first time. And I've never been able to get a copy of that worksheet.
All right. I note that you haven't moved to modify the child support order based on those circumstances, Mr. Pope.
Well, no, that's why I contacted the DCF to have it modified based on all of that, because I can't afford a lawyer, and I've tried to do all the free legal aids, and they'll tell me where to go to find the worksheets, but then they say they can't help me fill them out. They can't give me any legal advice over the phone.
The focus now shifts from past obligations to future calculations. The father argues that his income has been evaluated incorrectly because self-employment expenses were never properly considered. This is a strategic pivot. Instead of defending prior non-payment, he attacks the foundation of the support calculation itself.
There's pretty much no free legal aid available as far as I can find for divorce matters like this, other than the actual filing divorce in the first place.
Isn't it a basic rule that someone that's self-employed does have the right to deduct reasonable business expenses, which is connected with the generation of that income?
Yes, Your Honor. I believe that's appropriate.
Of course, he'll have the burden of documenting his actual gas expense that he refers to. Can you do that, Mr. Pope?
I mean, I don't have it saved. I have not saved all the receipts, but I have the mileage on my vehicle. I put 75,000 miles on the vehicle last year doing Uber and Lyft, and within the apps I can show how much miles were done each day. But it's
the production of your 2025 income tax return would be helpful.
Yes, and that was on there.
What was on there?
The tax deductions for the business expenses.
Okay, have you turned that over to Ms. Hawks or?
No, they never requested that from me.
Well, I'm just saying that what you're certifying to the federal government under penalties of perjury would have some validity here regarding your business expenses.
Yes.
Now, perhaps you're claiming business expenses that the IRS recognizes that perhaps this court wouldn't. But until that's turned over to Ms. Hawks for her and her staff's review, then I don't know how we determine that. So if you want to have these reasonable business expenses contemplated by the child support worksheet, you're going to need to turn over your 2025 tax return.
Okay, I will be happy to send that over right now to her if I have her email address.
I think it's on her paperwork. At least it's supposed to be.
Well, and what about any new jobs he started since then? Are we going to be?
All I have is the kslegal@ywcss.com. Is that correct?
That's the correct email.
Yeah.
Your Honor, there is one other issue. I'd just like to point out that since this was filed, which was really not that long ago, the motion was filed in April. One of the children has changed age brackets from 6 to 11 to 12 to 18, and that could significantly change the number.
Well, the current age of the child should be reflected accurately in the child support worksheet. So if that's taken place, then the child support worksheet needs to contemplate it.
I agree, Your Honor.
The court does approve the $100 per month income withholding order arrearage portion until paid in full. And I don't think there's any question that there is an arrearage. The question just may be how large that is.
Sure.
Okay. Jump back to Ms. Locke for a moment. Are there any other matters that the court needs to rule upon raised by you in your response?
Judge, the only issue that we haven't addressed is Ms. Pope is under the impression that Mr. Pope is now employed and is no longer self-employed, but actually a W-2 employee. If that is the case, if he's providing new income information, we would just ask that his new employment information be provided.
Mr. Pope?
I have taken a part-time job. I'm still yet to start it. I got hired at the beginning of February. I went through the online training and got very small paychecks from that, of which 50% was deducted for the arrears. And then Other than that, I've been just waiting on hold for my manager to get everything. I got an email from her yesterday morning. She has said that she sent everything over to the state for them to approve me to work with foster kids. And once we get that approval back, then I'll actually be able to start working. And that will be part-time. They said probably 15 to 20 hours per week at $22 per hour. And then I
Working
have
for
got
what agency?
it's working for Foster Adopt Connect. They work with foster kids doing behavioral intervention work with to deal with trauma-related behaviors.
Well, this appears to be a sure thing that you're going to be doing this work, correct?
Yes, and it will replace some of my Uber and Lyft income because I can't keep doing Uber and Lyft. My truck's falling apart. And I've also gotten hired now by First Student, which is the school bus company here in Wichita. I have to take the CDL learner's permit test and get my CDL learner's permit, and then they will start doing paid training to get the CDL. And after that point, which is 4 to 6 weeks, then I'll get hired on as an actual bus driver. The paid training portion is $13.75 an hour, and is 40 hours like Monday through Friday. And then after that, they said it's part-time, but it's like 30 hours a week for the actual shift, and that's at $23 an hour. So neither job has actually started paying me as of yet, and I'm not sure when I'll actually get my first paychecks.
Well, when you do get them, you're going to need to turn those over to send those to Ms. Hawks and Ms. Locke. Mr.
Okay.
Pope.
Okay, Your Honor.
They can take appropriate steps at that point to further modify child support if appropriate. I don't want to hold up modification forever waiting on you to get some paychecks in the future. So I think we're going to go on existing numbers, but you've got this duty to disclose these changes in your income. And if you do that, then the professionals can take appropriate action as they deem appropriate. If it's going to be some sort of significant change in child support.
Understood, Your Honor.
And if you don't, then you very well may be liable for sanctions for not doing it. You understand that, Mr. Pope?
Yes, Your Honor.
So just compliance is necessary. Okay. All right. So Ms. Locke, we've addressed all of your points.
Yes, Your Honor.
All right, Ms. Hawks, is there anything else from your perspective that we still need to address here?
Nothing further from you, State, Your Honor.
And again, as usual, you'll be responsible to draft the journal entry of modification which stems from today's proceedings, covering the matters that we've addressed here in court.
And I did just email that tax return over to Ms. Hawks.
Okay. I want Ms. Locke to have it as well.
Okay, I don't have her. I couldn't find her email in my email folder.
Did you receive a copy of her response?
Did I?
She filed a formal response in this case April 12th. Did you receive that?
Let me see.
Because her email address is on it.
Yeah, when I try to search for her name,
it says that certificate of service says it was sent to you at your last known address, whatever that happened to be. It's not stated. I'm just saying that if you have a copy of any of her pleadings, her email address is on there.
Yeah, and when I'm searching for her name to try to find them, nothing's coming up.
Okay.
So
any objection to the court giving it to him, Ms. Locke?
No, Judge, or Allie can forward me his email. Either way.
Okay. I just want to make sure you have access to this information.
Thank you, Judge.
All right. All right. Anything further from any of the parties?
No, Your Honor.
All right. Then if there's nothing further at this time, the Pope matter will currently be in recess, and that will conclude this segment of the docket. So we'll address things again at 10 o'clock, which I guess we're there.
The final segment focuses on transparency and future compliance. New employment opportunities create the possibility of higher income, which means future support obligations may also change. The judge refuses to delay current decisions while waiting for hypothetical earnings. Instead, he establishes a disclosure framework. The father is instructed to provide updated information as soon as circumstances change. This reflects a broader judicial philosophy that values ongoing honesty over perfect predictions. The court understands that financial situations evolve. What it cannot tolerate is silence when those changes occur. The repeated emphasis on disclosure and potential sanctions sends a strong message. Family court operates on information. The moment a party withholds that information, the system begins to break down. Compliance is not treated as optional. It is treated as the foundation of every future ruling.